Teachers are entitled to due process, which refers to the use of legal rules and principles established to protect their rights. Firing a teacher for incompetence requires a lot of documentation and effort on everyone involved, and obtaining the documentation can be very burdensome, and few tenured teachers are dismissed using formal documentation. Instead, administrators sometimes use less formal procedures for excluding incompetent teachers. So, for example, these procedures include counseling incompetent teachers out of the profession and suggesting and financing early retirement. Cases dealing in educational issues can be heard by federal or state courts, as shown on the slide. A state court adjudicate cases that involve state laws, state constitutional provisions, school board policies, and other non-federal problems, where federal courts decide cases that involve federal laws and regulations or constitutional issues. Most cases pertaining to elementary and secondary education are filed in state courts. However, to keep from overburdening court calendars, both federal and state courts usually require that prospective litigants exhaust all administrative avenues available for a resolution before involving the court system. There are two clauses that are most frequently cited pertaining to the First Amendment, and it's the Establishment Clause, which prohibits the establishment of a government-sanctioned religion, and the Free Exercise Clause, which protects rights of free speech and expression. 14th Amendment cases have addressed the issue of school desegregation as well as the suspension and expulsion of students. The 14th Amendment must show that a liberty or a property interest is a major element in the court case. The liberty interest is involved if a person's good name, reputation, honor, or integrity is at stake. Certification of employment is pretty much just the teacher possessing a certificate and having gone through a legitimate background check, and in some states they're required to undergo fingerprinting. For employment contracts, this pretty much is just saying that teachers being hired by local school boards must comply with laws that prohibit discrimination. And teachers are entitled to tenure, which protects them from dismissal without cause, and they are entitled to due process for dismissal. For negotiation and strikes, teachers have the right to form and belong to unions and other professional organizations. For protection against assault, this has become an issue more recently, mostly in secondary schools, and courts generally convict defendants who have violated a teacher or state criminal codes, and teachers are encouraged to report criminal charges and initiate civil suits for assault and battery. For protection against unreasonable search and surveillance, teachers have Fourth Amendment privacy rights that protect them against unreasonable open-ended search of their property, such as a desk being locked in their classroom or a car in the school parking lot. Freedom of expression. Courts tend to uphold teachers' rights to express themselves in public or in school. However, in determining whether the expression is protected under the First Amendment, the court considers the effects on school operations. So pretty much if the teacher is performing correctly and her expression or what she's expressing complies with her lesson, it's generally okay. Academic freedom refers to the teacher's freedom to choose subject matter and instructional materials relevant to that course without interference from administrators. Teacher as an exemplar. An exemplar is considered an example to students of high moral standards and impeccable character, conservative dress and grooming, and polished manners. Tort liability and negligence. Torts are civil wrongs, and individuals who have suffered through the improper conduct of others may sue for damages. Reporting child abuse is a big part of teachers' rights. It's the teacher's responsibility, and teachers could get in trouble for neglecting to report suspected child abuse. And copyright laws. A copyright gives authors and artists control over the reproduction and distribution of works they create. Fair use is something that teachers have to go by, and it's a legal principle that allows use of copyrighted materials without permission from the author under specific limited conditions. The justices presiding over the case all had similar opinions that the content of the books are not sweet and sugar-coated, but the school board should retain the right to vote on books and approve or disapprove based on content support. U.S. schools and libraries may eliminate based on vulgarity, but cannot censor ideas. Teachers should, however, provide a rationale for explaining the relevance or relation of the book, as well as offer alternate material. This case has to do with the teacher neglected to review materials before distributing it. The material was found to be inappropriate, and the teacher was dismissed for willful neglect of duty. The majority opinion states that it is beyond question that the school board can punish the appellant in some manner short of dismissal for her act of gross negligence, but does not recognize the blatant abuse of power inherent in this court's determination of what the appropriate penalty will be. From what I took of what I read was that this case had it had been appealed a couple of times. The first time the court ruled that the board's decision to dismiss the teacher was okay, and then the appellant, which would be that teacher, came back and said that it was unlawful or wrong of them to have done that. And so DeVito versus Board of Education is pretty much the appeal of the initial case. This case is about a teacher that engaged in traditional horseplay on the last day of school that included a water fight, despite explicit warnings from authorities that there would be extreme punishment if anybody, students or teachers, participated in it. The school board, after the school board hearing, who's the teacher, was found guilty and suspended for 15 days. She appealed this decision, and trial court overruled the suspension. So then the school district appealed, and the ruling stood, but her behavior was recognized as unprofessional and unbecoming of a teacher. But they did not think that it rose to the level of being immoral. It was found that Baldridge did not mean to be sexual or phallic with his comments, and students weren't offended by his inappropriate comments to them. He would use references that would come across as sexual or inappropriate to students while he conducted his class. Judges stated, as public servants in a special position of trust, teachers may properly be subjected to many restrictions in their professional lives, which would be invalid if generally applied. Finnett violated the administrative policy of the principal of Muir High School. He was noted to be an effective teacher, but was still dismissed for his violation. A child climbed on a jungle gym during PE and tied a jump rope to it, and the teacher wasn't looking in that direction, and the child attempted to swing off of it when he then fell and broke his arm, and that's what this lawsuit has to do with. An overweight student expressed concern about performing a backward somersault during PE. The teacher made her attempt it anyway for a grade, and the student snapped her neck. This case was awarded $77,000 for damages. Another incident that is similar to this case is a student that was in introductory chemistry class blew his hand off while completing the assignment to make gunpowder. Both of these were considered, well, the first one was not considered something that could have been foreseen or negligence on the teacher's part, and the second, where the student was making gunpowder, was considered to be a foreseen circumstance. This has to do with a student or students who wore armbands in protest of the Vietnam War. The school made a policy a few days before they did this, resulting in suspension of whoever protested in fear of the protest causing problems. And Tinker won, as you can see, with 7 votes. It said it was the courts decided that it was a violation of students' rights. Bethel's students gave a speech, or a student gave a speech promoting his friend for a class election in an assembly of around 600 people. During his speech, he used a phrase that observers believed to be a sexual reference. And as you see in the PowerPoint, the court found that it was appropriate for the school to prohibit some speech if it was considered vulgar or offensive. In the case of Hazelwood, the ruling further stated that a school could disassociate itself not only from speech that directly interfered with school activities, but also from speech that was ungrammatical, poorly written, inadequately researched, biased, prejudiced, vulgar or profane, or unsuitable for immature audiences. The decision was a clear restriction on students' rights as previously understood, according to In this case that reached the Supreme Court, it was stated that students must be given notice and afforded some kind of hearing before being suspended or expelled. In this case, a 13-year-old girl was strip searched by a teacher for the assumption or the knowledge that she had ibuprofen on her. And the initial procedures were considered appropriate or ruled appropriate, but the strip search itself was deemed unconstitutional and a major violation of her privacy. In this case, the court ruled public schools must allow students' religious, philosophical, and political groups to meet on campus on the same basis as other extracurricular groups. Permitting such meetings, the court stated, does not mean the school endorses or supports them. Equal access applies not only before and after school, but also during non-instructional time during the school day. Congress has passed legislation aimed at making it less cumbersome for administrators to suspend disabled students who violate school discipline rules. But of course, as I said in the PowerPoint, teachers have shown that practical issues are still murky, and it's kind of difficult to maintain a balance or a good balance between what they can and can't control themselves and what's appropriate to let slide and not.